Dying without a will in Georgia, the minor child guardian trap. Let's talk about that. Imagine this for a second. You and your spouse bought a beautiful home here in the greater Atlanta area years ago, and you've raised your babies there. You've made incredible memories, and it is your safe haven. Then the unthinkable happens, and your spouse passes away unexpectedly, and you're grieving. It's a horrible time, but you try to comfort yourself thinking, well, at least the house is now fully mine. If I need to sell or refinance to make it a little bit easier, I can. But when you try, a closing attorney delivers the absolute devastating blow. You don't own 100% of your home because your spouse died without a valid will. Georgia law decides who gets everything. The state steps right in and it takes a sledgehammer to your property title and automatically splits ownership between you and your minor children. And because the kids are under 18, the probate court freezes your ability to list, sell, or refinance your own primary home, all without a judge's permission. We are talking about exactly what this trap is and how it happens and the steps you need to take right now to protect your legacy. Welcome back to the channel. If you're brand new here, welcome. My name is Tonya Byrd, and along with my husband, Tom, we run the Byrd Group, brokered by Keller Realty, Atlanta partners. We handle lots of real estate, but our team specializes in probate. We went out and specifically seeked out the extra education to become probate specialists because we were tired of seeing good people make massive, expensive mistakes during an already heartbreaking season. Now, before we get in deep into this trap, here's my mandatory disclaimer that I put on the videos. I am not a probate attorney, I'm not a CPA, and I'm not a financial advisor. I am a real estate agent who understands the ins and outs of the probate process. We always tell people to go see qualified professionals for guidance in specific areas. So now let's bust a huge myth out of the gate. Most married couples truly believe that if one of them dies, everything automatically goes to the surviving spouse. But in Georgia, if your deed doesn't explicitly contain the phrase joint tenancy with rights of survivorship, it is not automatic. So if the deed is silent and it doesn't have those words, it is treated as tenants in common, meaning your spouse half of the house goes straight to the probate court. And when somebody passes away without a valid will, it is legally called dying intestate. And when that happens, Georgia intestate laws step in and they follow a very strict order in what gets inherited. And the state doesn't care about your beloved one, what they wanted, what they promised to you verbally. If it's not writing on a valid will, the state laws rules the day. Under the Georgia law, if you pass away with a spouse and children, your spouse is guaranteed at least 1/3 of the estate, and the children get to split the rest amongst themselves. Now, think about what this means for your house. Once probate is opened up, you end up owning the house together with your kids. Now, if your kids are adults, co-owning a house can certainly create a tricky family mess that maybe if people don't agree, but Lord help you if your children are minors under the age of 18. In Georgia, minors cannot legally sign a listing agreement or approve a purchase contract or even sign a deed to a buyer. So they just can't do it. And because of that, the probate court steps right into your private family business, and the court appoints a financial guardian over the minor children to oversee their portion of the house. And here's the ultimate trap that shocks surviving parents. The court does not automatically assume you are the right person to handle that money. Even if the court does appoint you, you are now completely micromanaged by a judge. And if you want to sell that house because you can't afford the mortgage on your single income, or you want to refinance and pull some of the equity out of it for life expenses, you are completely blocked. You cannot just push the easy button and list the house. You have to go hire an attorney, file a formal petition for a leave to sell, to wait for the court to approve, and hopefully nobody objects. In fact, we've done a whole separate video on the breakdown exactly how those leave to sell contracts work and the special verbiage that you need. So click in the links below to find that video. So this minor child trap just doesn't cause a massive headache. It makes expenses skyrocket. First of all, the court supervises the fees, and every single petition, mediation, or hearing you have to get permission from the judge costs money. And that's exactly why you hear horror stories of simple estates spending $10,000 to $20,000 in probate. It's not because probate was designed to be expensive. It's because conflict and court involvement makes it more expensive. Second, ongoing surety bonds. If there are no will to waive it, the court is going to force you to buy a probate bond. And the bond is basically an insurance policy that protects the heirs just in case a personal representative goes wild and spends all the money. And you have to pay this bond premium out of your own pocket every single year until the probate is closed. And the higher the value of your home that might be in the greater Atlanta area, the higher the premium is going to be. Third, the foreclosure threat. While you are jumping through extra hoops for the court, the bank's clock is still ticking. Remember, Georgia is a non-judicial state when it comes to foreclosures. And if you're falling behind on that mortgage payment because you are down to one income and the bank can absolutely foreclose on you in as little as 60 to 90 days, and the probate court does not stop a foreclosure. So if you're watching this right now and your spouse is still alive, please don't sit on your laurels. Go online and pull out that property deed and take a peek to how it's titled. If it does not say joint tenants with rights of survivorship, get a real estate attorney immediately. For a couple of $100, they can fix the language on your deed and save your family months of stress and thousands of dollars down the road. And please, while you're at it, make sure you have a valid will in place. Now, if you're in the middle of this process, because there wasn't any pre-planning, I'm sorry. I know this is tiresome. Emotions run high, and it is not for the faint of heart. But you do not have to handle the logistics alone. You can surround yourself with a good probate attorney, a CPA, and a real estate agent who understands how to market a home when the court approval is involved. So to help you get your bearings, we put together a complete free ebook called Probate Real Estate: Avoid 7 Biggest Mistakes. It has timelines on it and mistakes we've seen people make to help them out, to help you get organized. So you can download it right now by using the link below in the description. If you are navigating the probate process anywhere in the greater Atlanta area and you have questions about the house, please reach out to us. All of our contact information is below. Feel free to give us a call or text or schedule a quick one-on-one chat. We're here to support you through the whole picture. And if in your other parts of Georgia, we can definitely connect you to agents who also specialize in probate. If you found this video helpful, consider subscribing to the channel. And maybe this next video that will pop up, you might find it helpful as well. Until next time, I'll see you later. Bye.